Hi, I'm Matt Lewis with MLF Legal, and again we're continuing our series on general terms and concepts, issues with workers' compensation law in Texas. Today is the 9th installment in the series, and we're going to talk about reporting a work injury. If your employer has workers' compensation insurance, then you got to jump through a few hoops to get your claim going after an injury. There is a legal requirement to report your injury to your employer and to file a claim with the Division of Workers' Compensation. Reporting an injury to your employer is as simple as telling a supervisor or an HR person about your injury. Any supervisor will do, and any HR person will do. Now you're going to want to explain what your injuries are and that they resulted from your work activities. And the important thing to remember is that you only have 30 days to report your injury to your employer, or you could lose the right to workers' compensation benefits forever. If you have an injury from a specific event, like falling down and breaking your arm, then you have 30 days to report that injury event to your employer from the date the accident occurred. If you have an occupational disease, like a chemical exposure or carpal tunnel from typing, then you have to report that injury within 30 days from the date that you knew or should have known that your injuries were work-related. Now you also have a responsibility to report the injury to the DWC, to the Division of Workers' Comp. And this is done by filing form number 41 with the division. And there's a 1-year deadline to file this form, or again, you can lose the right to get workers' compensation benefits forever. So you can see that the penalties for failing to report your injury can be fatal to your claim. Now, if you've missed the deadline, then you need to know that there is an exception to the rule. And you can avoid these penalties if you had good cause for failing to report the injury on time. And one of the most common findings of good cause is when an injured worker trivializes their injury. So I did a case the other day for a guy named Ben. And when he got hurt, he didn't think that his injury was that big of a deal. So he didn't tell anybody about it because he didn't want to jeopardize, his job or have anybody, take any action against him because he filed a claim. So he kept it to himself. The problem was it wasn't as minor as he thought it was, and it didn't go away. And then it required surgery. Well, a little something then turned into a big deal, and he missed the deadline to report the injury. So we were able to show that he trivialized the injury by considering it to be very minor and something not worth reporting. But the trick here is that we have to prove in these situations that the belief that something is minor and not serious has to be reasonable in order for it to work at the division. So the best thing to do if you get hurt at work is to report it immediately. This way, the details and any evidence that can be documented can be preserved, and that way you're able to prove your claim later. So if your claim gets denied because of a failure to report your injury on time, you're going to need to see a lawyer and figure out how to move your case forward, considering what actions you took and what exceptions might be available. So as always, we want you to work safe, but if an accident happens, call MLF Legal.